This is John from Michalsons, and I'm going to be sharing some key insights about POPI, the Protection of Personal Information Act, and its impact on pension funds. Pension funds or retirement funds process a lot of personal information, like the employment or financial history of a member, or the personal information concerning a member's health. They also process a lot of personal information about beneficiaries, which can sometimes be children, which has its own set of implications. Funds also have third parties, like administrators and other service providers, who process personal information for them. Funds must protect personal information to ensure that a thief does not steal the member's benefits, savings, or investments. Identity theft actually is a big issue in South Africa, and it does happen a lot. It's the responsibility of trustees to ensure that the fund processes personal information lawfully in accordance with POPI. There's a growing trend that trustees are held personally liable. Not the fund, the trustees are held personally liable for damages suffered by members. You obviously want to try and avoid this, and good governance of funds is important because it leads to better outcomes, which in turn lead to better investment returns. Members trust you with their retirement benefits and their personal information, and it's really important that you don't lose this trust. We normally speak for about half a day on this topic, and what I'm going to try and achieve in the next few minutes is to share some of our key insights on POPI and pension funds. Firstly, it's to say that there is time, but you need to start working towards complying with POPI now. So POPI was enacted by Parliament in November 2013 already, so we've had the law for quite some time already. We're currently waiting for the commencement date, which we guesstimate to be in the middle of this year, 2015. After that date, you will have a 1-year grace period within which to comply with POPI. So really the key date is about the middle of 2016. That's when you as a pension fund need to comply with POPI. And after that date, if you fail to comply, the consequences of failing to comply will then apply. So we've got time. We've got at least 18 months, but there's a lot to do. And so now's the time to start planning and thinking about how you're going to achieve compliance. The next key insight is that you must take practical, effective action to comply with POPI at the lowest cost. So what we mean by this is don't get caught up in extensive exercises that can be very costly, or get caught up in buying various different products that can be very expensive. Really keep your focus on really protecting personal information. So keep asking yourself the question, is this thing that I'm doing going to actually protect personal information? And use it as a bit of a sanity check to see that that's the case. So to give you a few examples of practical effective action, the first one to give you is relating to personal information contained in hard copy documents. There's a lot of personal information in printed documents. POPI applies to that and requires you to protect that information. So the practical easy thing to do is to shred any hard copy documents that you're throwing away to ensure that somebody can't pick up that document and get the personal information from it. Very easy. Buy some shredders and make sure all documents being thrown away are shredded. The next one is to deal with incidents of failing to protect in an effective manner where you can learn from that incident. And the best way of doing this is to put an incident response policy in place, which sets out clearly what you're going to do when you fail to protect. And incidents happen. It's impossible to protect personal information 100% of the time. It's just not going to happen, so you will have an incident. The key thing is to deal with the incident well and learn from that so that you can protect it and stop the same incident happening again in the future. The next one is focusing on unstructured data. So structured data is often in a database that's manipulated by an application, and often there's very good security around that structured data and also good access control. So it's very protected in other words. What's the scary bit is when that data gets exported out of the database into a spreadsheet, say it's the list of members of a pension fund or retirement fund, and that then is an unstructured list that contains a lot of personal information. It could be emailed to somebody, could be stored on an external flash drive, all of which exposes it to a lot more risk. So focus on where you have unstructured data and try and minimize the amount of unstructured data that you have. Another quick win or something, a practical thing to focus on would be to ensure that you have good quality information. POPI, one of the conditions is that you need to ensure you have good quality data if you're deciding to process that data. But from a pension fund's perspective, from a business perspective, you need good quality data in order to function. So it's a good example where there's both a business and a regulatory requirement which you can focus on. All right, so another key insight is you need to know when you, as the pension fund, are responsible. There are many role players, and in different circumstances, different people are responsible. But essentially, whenever you as a pension fund are determining why personal information is being processed and how it will be processed, you are responsible and must protect it. So there could be examples where a third party is processing for you. If they're your operator. You're still responsible for the way in which they're processing the personal information. I like to use the analogy of a hot potato. Personal information is like a hot potato, and whoever's got that has the responsibility for protecting that personal information as a general rule. But really, so as a pension fund, you need to work out when you are responsible for it. There will be instances where the employer is responsible for the personal information of their employees. It won't be the pension fund. So you need to know when you're not and when you are. Another key insight of ours is that you should focus on protecting account numbers. Now, POPI defines an account number to be any unique identifier that enables a data subject to access their own funds, like retirement funds, or credit facilities. And POPI has increased the consequences for failing to protect account numbers. So it's not a criminal offense if you fail to protect personal information in accordance with the conditions. But if you don't protect account numbers in accordance with the conditions, it is an offense, and you could be fined 10 million rand or jailed for up to 10 years. It's very unlikely anyone's going to jail, but that fine could apply. So the key point is Parliament wants us to protect account numbers. Pension funds have account numbers. Thieves want those account numbers so that they can steal retirement funds of people. So that's something to focus on. And a good example of what you can do to protect account numbers is you can obfuscate some of the numbers in an account number. So put crosses through some numbers, but leave some 3 or 4 numbers still visible. The person whose account number it is will know it's their account number, but nobody else will know what that number, the full number is, which is important. The next relates to governance, and it's really working out who is responsible within a pension fund for complying with POPI. So ultimately, it's the trustees who are responsible. Collectively, the trustees are responsible, and they could be held personally liable, although that's less likely than the fund itself being held liable for failing to process lawfully. So that's the key element, but there's another very important person within a pension fund, which each pension fund has, and that's the Information Officer. Now, the Promotion of Access to Information Act, or PIA, has been in existence for about 12 or 13 years in South Africa, and that law says that everybody, so a pension fund, has a person called the Information Officer who is responsible for dealing with requests for access to information and then providing that information. So when Parliament enacted POPI, Parliament said, well, who are we going to make responsible in a pension fund for POPI? And they said, we'll make it the same person, that information officer. Now, the information officer in a pension fund is often the principal officer. That is the person. But you must work out who your information officer is, make sure they understand what their responsibilities are, and make sure that everybody else knows that they are the information officer. That part of that is by specifying and saying specifically who the person is by name in your PIRE manual. That's an important thing to do. So that's an important step to take from a governance perspective. So those are the key insights that we wanted to share with you today. We hope you found those useful. Thank you very much.